Hi, good afternoon, everybody.
Good
Thank-
afternoon.
Afternoon.
Today is Thursday, March the 7th, 2024. And the Board on Professional Responsibility is convened in the matter of Jahan A. Carter, board docket number 22-BD-052. Will the parties please identify themselves for the record, starting with disciplinary counsel?
Jack Betzler for the Office of Disciplinary Counsel.
Thank you.
John O. Iwanage II on behalf of the respondent, Ms. Jahan Carter.
Thank you, Mr. Owanage. Let the record show that Michael Tiger, who is one of our attorney members, is recused and will not be participating in this case. And let the record also show that Ms. Sharon Rice Hicks, who is one of our attorney members, is not in attendance today. Board Rule 13.6 allows an absent member to participate in the decision of the board by listening to the recording of the oral argument, absent an objection from respondent. Respondent, do you object to the participation of our absent board member, Ms. Rice Hicks?
No.
Thank you. So we're here on exceptions to the hearing committee report from respondent, who will proceed first. Mr. Wanage, you'll have 20 minutes. Do you want to reserve some of your time for rebuttal?
Yes, I'd like to reserve 5 minutes for rebuttal.
Okay, thank you. So you can proceed when you're ready.
Thank you, Madam Chair. On behalf of the respondent, Ms. Jahan Carter, my first initial ask of the board is to make a finding that a dismissal is the appropriate way to resolve this case. Why do I ask and make that recommendation and ask of a board? One, the hearing committee made a finding that there was a 3.3 violation as well as an 8.4 violation. Taking the 3.3 first, the facts of this case are unique, and as we stated in our brief on behalf of Ms. Jahan Carter, it is unique in its very sense. One is Ms. Jahan Carter was representing an individual by the name of Ms. Collier. She subsequently filed a bar complaint. At the time that she filed a bar complaint, she was owing fees to Ms. Carter. There was a negotiated discipline at the time. At the time, Ms. Jahan Carter was represented by another lawyer. During the negotiated discipline, there was a finding made, at least with respect to the statement of facts, that was reviewed by Ms. Jahan Carter and her counsel. After review, it was executed. It was filed and approved by the board and the court. My understanding in looking at all the documents in support of that negotiated discipline, what Ms. Collier, under oath before the hearing committee in this case, as well as the agreed statement of facts for negotiated discipline, there was no finding of any of the 8 things listed by Ms. Collier in her allegation. I specifically recall asking her during the hearing, I went paragraph by paragraph in terms of the 8 things that she alleged in the complaint that she filed. And she agreed with me because it was obvious that there was nothing that was sustained or part of the negotiated discipline that my client, Ms. Jahan Carter, entered into.
Mr. Ivanage, isn't it the case, though, that the entirety of the discipline that she agreed to in the petition arose from Ms. Collier's bar complaint and Ms. Carter's representation of Ms. Collier in that matter?
That brings it, and I thank you for that question, because that was going to get me to one of the issues that I wanted to raise, but I'd rather take it on at this point. With respect to bar complaints, and then the board knows how these things work. Specifically, a bar complaint is filed, and the bar then, or disciplinary counsel, goes on into their investigative process. Other things are found other than what was originally filed. And then prior to us getting into negotiated discipline, bar counsel may get a complaint that, say, a check did not go through an attorney trust account. And then when they've investigated, they may find that it was an accident But then in the process, there may be something else that disciplinary counsel will find. They may start to prosecute that matter, which technically speaking, it is not the original matter that came before the disciplinary committee. So in this case, I will agree with you that this started with what Ms. Collier filed and also with what Ms. Lake filed. The hearing committee said that there was nothing received formally from disciplinary counsel, said that the Collier complaint was dismissed. But then, inversely, there was nothing received as well by Ms. Carter or her counsel that the Lake complaint was dismissed. So yes, I agree that it started out with the Collier complaint, but none of her allegations, all 8 of them, were sustained or made part of the negotiated discipline. And then what is troubling, and I believe it should be troubling for the board in this case as well, is it is okay when we look at these cases and then we're trying to impose discipline. But then the question that I want the board to also consider in the Jihan Carter case is the process. There was a vehement objection by Ms. Collier to the negotiated discipline. She put it in writing and then appeared and talked about it. This matter was brought to the attention of disciplinary counsel. At no point did disciplinary counsel say to Ms. Jihan Carter, you're out of line, or you should withdraw this, or we're going to make this part of a complaint. Everything went through. She, in good faith, believed that what she stated was accurate.
Was disciplinary counsel simply silent about what they knew, or was that something that was discussed with her? These statements in her small claims action?
The small claims actions were pending, and then Ms. Collier brought it to the attention of disciplinary counsel, and then the hearing committee, when she objected and said, look at what she filed. So I will submit that based on the record that I have, because I wasn't her attorney at the time, but based on the record that I have, I will submit that disciplinary counsel was well aware of this complaint.
But there's no record about what was discussed, if anything, between disciplinary counsel and respondent?
No, as I understand it, as Ms. Jihan Carter testified at the trial, at the hearing, and then Ms. Collier testified as well. She brought it to the attention of disciplinary counsel and then objected to it. Nothing was done. It was approved. Ms. Jihan Carter did not get any communication either from her lawyer representing her at the time or from disciplinary counsel that there's something wrong about what she had requested or what she had stated. So I will submit that at that point, any reasonable human being, looking at the court's decision in Romanowski, any reasonable person will believe in good faith, or like Romanowski said, if you're filing something like false billing, it's like backers has to show that that additional step that the individual knew that there was something dishonest about what they were doing.
Mr. Walker had a question for you, Mr. Wanagay.
I apologize.
Yes, no, that's okay, Mr. Wanagay. It's on a slightly, well, on a different point here. The statement in the small claims matter made by your client that the complaint had been dismissed because it was unsubstantiated. Am I correct that that was made before the negotiated discipline process was completed?
I believe the statement was made when she filed it on April the 14th. I don't have the exact timeline in front of me, but my understanding was that back at disciplinary counsel, I keep calling back counsel, disciplinary counsel and her attorney and Ms. Collier, and then as well as the respondent were well aware of the pendency of the small claim matter. It's my understanding that it was filed on the 14th of April, which will be prior, which will be after the negotiated discipline was done.
So my question is, your client while a negotiated discipline process is pending but not completed, your client makes a statement that the matter underlying or based on which the negotiated discipline was started, statement that was dismissed. Dismissal confers a finality, implies a finality of action. But couldn't the negotiated discipline process have broken down, in which case the charges against your client, the complaint, would have been as live as ever? Dismissal.
It had already broken down once, yes?
Right. So dismissal implies finality, and yet the matter wasn't finally resolved, the negotiated discipline. If that had broken down, the charges were still there. So how is that even dismissal? How did your client believe that scenario implies dismissal of a charge when they could still come right back up if the process broke down?
I understand where you're coming from. However, as she testified at the hearing, this may be a matter of semantics when individuals use certain words like dismissal and things like that. But I believe that what she was trying to convey as she testified at the hearing was that what she filed was unsubstantiated. Dismissal in this sense is there are 8 things that she listed. Bar counsel did not make any finding as to that. And then with respect to the negotiated discipline, this is what we agreed to. And this is what is going on. Yes.
Is there anything in the record from Ms. Carter's testimony about what she was hoping to accomplish by pleading? Anything about the status of the bar complaint in her small claims matter?
I believe that she responded. It escapes me now, but my recollection, but the board's reading controls. But my recollection, I may be mistaken, is that she said something to the effect that she filed it, and then when she stated that she was trying to convey that there was nothing that she did wrong, so that Ms. Collier was required to make the payment to her for services rendered. So I believe that that's why that statement, it's like, that's why they say you don't represent yourself. If you had a lawyer, it probably would have been worded differently, but it was inartfully worded. And then it gets me to the next issue, which is if a lawyer or an individual inartfully words something, how do we take that giant leap to say that this individual was being dishonest? In other words, she's not it's like, for example, I do bar counsel cases, I understand the process. She hired a lawyer to represent her because she doesn't understand the process and doesn't know how it goes. When there's a negotiated discipline, and then she reads,
Mr. Wanigay, to go back to respondent's statement in the small claims complaint, because there were 2 separate complaints, right?
Yes.
You filed one earlier, maybe the April one that you referred to, that was dismissed because it wasn't served in the right time period, and then she filed a second one later, and she kind of emphasized this dismissal, using more emphatic language in the second filing, saying that Ms. Collier's complaint had been dismissed as unsubstantiated. Are you saying to us that she had a reasonable basis and she was correct to say that the charges were dismissed? Or are you saying that she was mistaken, or that she's not, that she misused the word dismiss? Are you saying she was mistaken, but in good faith? Or are you saying that she was actually right, that she was right to say that the charges were dismissed?
Okay. I will say that I will adopt both. That she was right in the sense of a lawyer that doesn't practice in this area. I believe the first small claims complaint was in November, and then the 14th of April one was the second one. So the one that was an issue that the hearing committee took up was the subsequent one, which is the April one. But I'll say that the first one is that she's right in the sense that that claim, whatever claim that she made, including the testimony of Ms. Collier, was that none of that made it to what bar counsel was dealing with, and there was no finding in that regard. Of course, even though you negotiate discipline, unlike a criminal case where you can plead guilty to money laundering and then the government would dismiss wire fraud, bar counsel cases generally do not work like that. So bar counsel is not going to see a finding that is substantiated, but then choose not to go forward on it and say, instead, you're going to get this one. So that's the way she understood it. Then I will also say that even if the board does not find that the statement in itself is what a lawyer should believe, then it gets me to the second part, which I say I also agree and say that it applies, which is that she may be mistaken because she in good faith believed that once those 8 things did not make it to the negotiated discipline, that obviously bar counsel was not proceeding with it, and then it was dismissed. And then to further buttress the point that she was right or she was mistaken and in good faith believed it, that bar counsel was aware that Ms. Collier was objecting because there was a pending small claims case on April the 14th, but bar counsel or disciplinary counsel still proceeded to make sure that the negotiated discipline was approved, even over the objection of Ms. Collier, who not only wrote to the hearing
Is your
committee.
point in that, I'm sorry to interrupt, Mr. Wendigate, but as your time is elapsing here, is your point in emphasizing that you believe a claim like this was released by the statement in the petition, that no further claims would be brought, like as if it's the scope of whatever res judicata is from that petition would cover this conduct? Is that your point?
My point in a way in that regard is, I would say it
I don't
could
think
be,
there's latches here, in other words, right? So
yes, that's what I'm arguing, because it's like Ms. Collier brought a complaint, bar counsel investigates it, decides to bring a negotiated discipline on something else, an agreement is reached, bar counsel knows about it, nobody does anything, and then all of a sudden, boom, you wake up and then you refile after approval of the negotiated discipline and say she made a false statement. That should not be how disciplinary.
I believe she was sandbagged.
That's one of the arguments I would make, that she was sandbagged, because if it was brought to her attention, your matter is still pending and you're in further violation, it could be even a reason why bar counsel or disciplinary counsel will not even go into the negotiated discipline, because she will be in violation, because until it is approved, you cannot do something that violates your agreement to be of sound ethical attorney that you're supposed to be.
Do you reserve time? Is that right, Ms. Sargent?
Yes.
You did. Okay.
Yes, Mr. Wanige reserved 8 minutes for rebuttal, but and also he is out of time. But if people have questions that they would like addressed now before we hear from ODC, I'll let Mr. have extra time too. Dr. Hindle, did you have a question?
No, I'm sorry.
I have one more question for him if my other colleagues do not, because I think it would be good to hear your answer before Mr. Metzler's argument. One of the errors that you point up in your brief is the hearing committee's citation to paragraph 5 of Ms. Collier's bar complaint, and you believe that they should have, cited it. It's an objection, I guess, of incompleteness, and that they should cite the entirety of it, which would help you make your point, the point that you're driving home today, that the ultimate negotiated petition did not reach specifically what Ms. Collier was complaining about. And you seem to be given a very close reading to a bar complaint that's written by, a client, a layperson. And so, it certainly lacks precision, but I just wanted to ask you, sir, do you claim that paragraph 5, is it ambiguous?
It's ambiguous in the sense that the hearing committee only selected a portion of it. If you put the entirety of it, it's like it will then drive home the point that we are making in terms of the complaint itself on that paragraph 5, because specifically on paragraph 5 of the Collier complaint, she clearly states that respondent made false claim that she was able to practice in Los Angeles. And not that the respondent engaged in dishonesty and made false statements in her pro hac application. I mean, it's there in black and white.
And in the first specification of charges in Carter 1, that is indeed something that disciplinary counsel charged your client with, a Rule 5.5a violation, unauthorized practice of law in California. And then at the end of the day, that was not included in the negotiated discipline, was it?
No, it wasn't, because the attorney for Ms. Carter produced additional records in response to bar counsel to satisfy their inquiry. And that's why I believe that those ones were resolved, because bar counsel could not establish it under
Is that in the record, sir?
I don't believe it will be. I don't believe it's in the record because the attorney did not testify, and then Ms. Donaire, I believe, was the attorney on the other side, and she did not testify because she prosecuted the case.
Thank you.
Just
Walker.
a quick question, Mr. Wanagay. In what areas of law does your client practice?
Just civil.
And any particular area, does she in her practice enter into negotiations and
Define it was a transactional practice.
Yes. I would say that she's not sophisticated as most lawyers are in the field of transactional dealings in terms of contracts and stuff. She's relatively a new lawyer in terms of the practice of law.
She's an 09 law school grad, right?
Yes, but
bar admission is 09.
Yes.
What can you tell us about her practice, though, from the record?
The record, from the record, she testified that her testimony was complete in that regard. What she does, I mean, she used to do contract work. She used to share offices. It's not the type of practice where individual gets into a law firm. You have a mentor that will groom you and teach you things that you need to know. It's, I'll say, one of the pitfalls of solo practitioners, I will submit. That's the kind of practice that she had. But then with this, what happened in her original case, which is part of the record here, she's learning new things and how to do things and who to consult with. And I believe I remember a case similar to this, but it's like, I believe in Ray Abigail Askew had an issue where there was something that was mentioned in the discipline or in the Court of Appeals opinion. And then the subsequent matter, which I argued for Ms. Askew, I believe that the court put that into consideration in fashioning an appropriate resolution, because I believe that a resolution in this case, if it's not dismissal, but then the penalty and the sanction imposed in terms of lawyer discipline on the negotiated discipline should be enough to satisfy our ability to know that she's doing what she's supposed to do, including the probationary period required therein.
Thank you.
You're welcome.
Thank you, Mr. Wanagay.
Madam Chair.
Yeah, if you'd like, you can mute yourself while you're not arguing, and we can turn now to disciplinary counsel. Mr. Metzler, please proceed. And if you need extra time, obviously you can have it.
Thank you. And may it please the board, Jack Metzler for the Office of Disciplinary Counsel. The misconduct in this case is straightforward and the facts are largely undisputed. Ms. Carter initially lied in her pro hoc vice application to in the California court, and then she lied to the judge who was considering that application when she tried to explain how a false profile of an attorney was on her website. The court denied her pro hoc vice application because of her dishonesty. And then the client complained to disciplinary counsel that, among other things, Ms. Carter was denied pro hoc vice because she had made false claims to the court. Disciplinary counsel opened an investigation and brought charges based on that misconduct. And then Ms. Carter admitted to her lies when she agreed to the negotiated discipline. While that was pending, Ms. Carter decided to sue her client. And in support of her claim, she said that the client's complaint had been dismissed because it was unsubstantiated. That's the lie that we're talking about today.
So, Mr. Metzler, can you walk us through, we know that was the hearing committee's finding, but how would you describe from the record the basis for the finding that the statement about the charges having been dismissed as unsubstantiated was knowingly and actually false, as opposed to just ill-informed, making inferences from things that shouldn't have been made?
So I think one way to look at this is Ms. Carter focuses on this word dismissed, and her counsel says maybe it was an artful, or people can interpret things different ways. But this is the language that she chose, and the context in which she chose to use it was to support her claim in a lawsuit. And I don't recall the testimony specifically, but I'll take my friend's admission that she described it this way because she wanted to show that she hadn't done anything wrong in the representation, and she was therefore entitled to the fees that she was claiming. So the idea of whether it is dismissed, the reason we're talking about that word, or the reason it exists, is because Ms. Carter used that word to show that she hadn't done anything wrong in the representation, when in fact she had. She didn't have any basis to believe it had been.
What if she said? What if she said the charges were unsubstantiated or weren't found? There wasn't enough evidence for disciplinary counsel to move forward with the charges. Would that have been okay?
So so I think that actually is what the hearing committee found, essentially, with regard to the first small claims complaint, where Ms. Carter said, well, they were unsubstantiated, and the hearing committee thought, that's a matter of opinion. Maybe she thinks they're unsubstantiated, so we're not going to hold her to that as a false statement of fact. But the second complaint is much more specific. It says they were dismissed.
That's my question. That's my question, is that instead of saying that the charges were dismissed, if she said the charges were not substantiated enough to the point where disciplinary counsel moved forward with them, would that have been okay to say?
Well, I think that would be false as well. I mean, if you look at the paragraph 5, it says that the essence of that, it's not a very clear statement, but it brought to disciplinary counsel's attention the fact that Ms. Carter had lied to the court in seeking pro hoc vice admission. And
I don't read paragraph 5 necessarily to say that explicitly, but I guess I'm still asking the same question because I don't think you're answering it. Would it have been okay if she would have represented in this second small claims court action that the charges were not substantiated, or they weren't substantiated enough for disciplinary counsel to move forward on them? Would that have been okay for her?
No, I think I'll be clear that the answer is no, because the charge, the complaint described the dishonesty, and if you read our charging document and the negotiated discipline, it goes through it. It goes through the entire story. It starts out with, we received a complaint from Dominique Collier, and Ms. Carter represented her. And then she tried to get admitted pro hoc vice in Ms. Collier's case, and on. And it describes all of the dishonesty. It certainly is exactly what Ms. Collier was talking about.
I think her point, though, Mr. Metzler, is that if you will, the gravamen are the essence of paragraph 5. And I agree with both you and Mr. Winigate. It's ambiguous, but it was written by, a layperson in a bar complaint. So I'm curious, how much it really controls. But this non-litigating respondent makes this statement in the small claims matter that the defendant, Collier, in that particular small claims matter, that her bar complaint was dismissed as unsubstantiated. And I'm wondering if she's thinking only about, and again, this just goes to what the record shows from the hearing committee report, but whether it simply goes to the allegation that she was practicing law without a license in California, because that, one reading of paragraph 5 is that that's really the gist of what Ms. Collier is complaining about. And at the end of the day, while you charged the UPL violation, that's not included in the petition, in the negotiated discipline. And I'm curious as to what happened to that charge and what the discussions were, if it's in the record, with this respondent about why not.
Sure. So in our initial petition, we charged, we had 2 counts, one of which involved a separate client. And I'm not 100% sure about this because this argument wasn't really made in the briefs. But if there was a UPL charge, it must have related to that one, because the charge in the conduct described in count 2, which with regard to Ms. Collier, was all about the dishonesty to the California court, and then Ms. Carter's subsequent dishonesty to disciplinary counsel, where she made the same lies about the website as she did to the court. But regardless of that, I think it's important to look at the whole statement that Ms. Carter made. She said not just that it was dismissed, and I think you have my argument that if she had really no basis to believe that was just in her head. She at least had a responsibility to make sure it was true. It was at least recklessly in disregard of the truth. But beyond that, she made a more specific statement that it was dismissed because it was unsubstantiated. Now, even taking your argument, I disagree with it, but your point that maybe some of the things that were described in the complaint did not wind up in our specification of charges. There was no way for Ms. Carter to know what the basis of that. It could have been that we decided, we didn't have sufficient evidence to prove it by clear and convincing evidence. Or it could be that, we thought that a particular witness who would have showed it was not going to be reliable. There are many reasons that allegations that we may think are very much substantiated don't wind up in a charging document. And Ms. Carter had no way to know that.
Mr. Walker has a question.
With her. Rob.
So Mr. Metzler, you said that with regard to the statements she made, that she made them at least with reckless disregard as to whether they were true. That doesn't get you to a 3.3a violation, does it?
I think that's right.
And I would go back to, and the thrust of your argument seems to be, well, she should have known, or a reasonable person would have known. And whether or not that's true, I think I come back to Ms. Sargent's question. What are the specific facts in the record showing that she did, in fact, subjectively know that the statement in question was false? So I guess I would take this to what possible reason could she think that it was dismissed? This complaint talked about her dishonesty in seeking pro hoc vice, and then she admitted that dishonesty in the petition. She signed the negotiated discipline. All of the facts in there are facts that she admitted. So if she, is it a lapse of memory? Does she just not remember? How would she think that the complaint that is described in the negotiated discipline, which she agreed to, that shows that she knew, and she clearly knew the matter was not over. It was not dismissed. The negotiated discipline is a process, and the charges are still pending until that's complete. So I thank you for that. And then I have, what is your response to Mr. Iwanige's position that, to use a word that summarizes it rather colorfully, your client was sandbagged here, that disciplinary counsel knew about these allegations of a false statement in the small claims matter, and yet went ahead with the negotiated discipline, and then once that was concluded, came back and hit your client with another charge. What is your response to Mr. Iwanige's position and argument and statement with regard to that? So I'd first start by looking at the timeline, right? So this is an allegation. The charges here are based on a false statement to a court in the course of this small claims. That had already happened.
by the time it was brought up in the negotiated discipline. So so it's not like if we had said something to Ms. Carter, she could withdraw the statement. She had already, in our view, we think the first case was false. The statement in the first small claims case was false, but the second one was also false. So she couldn't take it back at that point. And then secondly, when this was brought up in the negotiated discipline, as a client is allowed to make a statement on the record, Ms. Collier did, the hearing committee was not allowed to address that. And so in its the opinion approving the negotiated discipline, you'll see that the hearing committee talks about this, and they say we can't do anything about it. Disciplinary counsel is free to bring additional charges if they think it's appropriate, and that's exactly what happened. And then finally, to the idea that we should somehow interrupt the negotiated discipline in order to bring a separate charge. I mean, that there is enough delay in this system where if we do that, we have this happens all the time. Attorneys who get in trouble for one thing often get in trouble for another thing, and we have cases pending. If we were required to stop every a negotiated discipline or another proceeding to add a new charge, some of these people would never get to a hearing.
Yeah, but Mr. Metzler, that's kind of a confusing point, because instead of a pause and saying, okay, so we already have this universe of acts, the alleged false statement was in the small claims complaint that existed at the time of the negotiated discipline. Either it was overlooked or wasn't addressed at that. Why wasn't that dealt with in the disposition through negotiated discipline at that time? Because in talking about delay, you also have to consider now Ms. Carter had successive matters come up based on things that were already in existence and known, or should have been known by ODC.
Well, so, I mean, consider what would have happened if we had decided to interrupt the negotiated discipline and bring this new charge. We're now a year plus later. The negotiated discipline we would have had to go back to the drawing board, and we would have recommended a greater sanction to take account for the additional act of dishonesty, and maybe Ms. Carter would have agreed to that. Maybe she wouldn't have, and maybe we would have gone to a contested hearing, and so forth. There's a lot of it would simply add to the process when we had a violation that Ms. Carter had agreed to. We had agreed on the sanction that went through, and she actually has served and is now had her license restored. So it is certainly it is efficient to have gone through that and then have this case then consider the additional act. So I mean, and frankly, what's before the board is not how well or whether the prior action should have gone a different way. It went exactly as the parties intended it to go, including Ms. Carter. And this is not the same action. This is not another allegation of dishonesty in the original case that Ms. Collier had in California. This is a separate act that Ms. Carter initiated herself by suing her client.
It arises from the same, client relationship.
Right.
I wanted to ask you a question about sanction, because it seems, looking at the cases, sanctions ranging from public censure to 60-day suspension, they may be more appropriate to something of this magnitude. And some of the cases like Sloyden, I mean, I feel like that case was much more egregious than this one. What would you say to that perspective?
I think that the most factually similar case is the Tun 2 case, which is cited in the board's opinion. That involved very similar facts, where the attorney had made, in the course of a negotiated discipline, had made statements in about the complaint that led to that negotiated discipline, and said no disciplinary action resulted from it, when in fact it had. And in that case, I believe the sanction was 1 year. So we did not take an exception to the sanction here, but I continue to believe that is the most analogous case. And since you asked about sanction, I do want to bring up one matter, and not to bring up a new argument, but there was a case that came down from the DC Court of Appeals, late last year. Well, not this morning, but late last year. It wasn't in the briefs, but I want the board to be aware of it. The case is Inri Doby 305 8th 3rd 780. And I bring it up because the hearing committee recommended that all but 90 days of the suspension be stayed in favor of a year's probation. And in Doby, what the court said was that stays of a suspension are appropriate for circumstances when circumstances exist that either blunt or explain the lawyer's culpability. And so, without making an argument on it, I just want the court to be aware of that when it evaluates, or the board to be aware of that when it evaluates the hearing committee's recommendation.
Mr. Metzler, there was a case that came down this morning.
Yes, there were two, and I don't have anything to say about this.
Well,
you did not have an opportunity to brief that one. Doby, I'm not sure about, but
yeah, I mean, Enri Zamora, it was a misappropriation case, I think, but
yes,
I think the court was I have an understanding. I'm not going to pretend here that I read through the whole opinion, but I have an understanding that the court seemed to think that there wasn't enough evidence that Respondent in that case subjectively was being reckless in the approach that he took to the statements that he made, his failure to give a full, complete, informed consent. I know this isn't a misappropriation case, but that, if it's looked at that high level, do you think that there's enough evidence in the record from which to infer a subjective intent, and a subjective and knowing intent to not once but twice lie in a small claims court complaint?
I think it is absolutely clear that Ms. Carter had no basis whatsoever to believe that Ms. Collier's complaint was dismissed because it was unsubstantiated. She simply could not, even if that were true, there is no way that she could have known that. And she has a responsibility to make statements to court that that are true after reasonable investigation and so forth. I can't quote you the exact standard, but she knew that the case that arose from Ms. Collier's complaint was absolutely not dismissed. And I'm not sure if I can say it any more convincingly than that. How could she not know? She had admitted to the lies that she had made before. I see my time has expired, but if there are any further questions, I'm happy to answer them.
Does anyone have any additional questions? Okay, so Mr. Metzler, we'll let you use that old trick of my time has expired to stop your argument. Mr. Owanige, your rebuttal.
My rebuttal to disciplinary counsel's argument is, bar counsel argues that there's no way Ms. Jehan Carter would have known that bar counsel was not proceeding or was not dealing with a case involving Ms. Collier. And so when she made the statement that she should have known that statement was reckless or dishonest. But then that brings me to the issue that I've raised, which is, if bar counsel believes that there's that if bar counsel believes that Ms. Carter will not have that information, wouldn't that be why it would have made sense when bar counsel had that information to bring it to the attention of Ms. Jihan Carter or her attorney, that guess what? We have this information. It's a subject of another matter to be dealt with at a later time. But then bar counsel says, oh, we have to proceed because we need to get to the end of this one and then continue another one. In other words, it's just like somebody who, I'm just thinking of a case that could come to mind. Somebody charged with wire fraud. In the course of investigating the wire fraud, you find out that there's a related money laundering as well. And then you say, let me finish the wire fraud, then deal with the money laundering, which may be related, because this is all part of the same universe, which is Ms. Collier. But so that's why it would have made sense that that was brought to her attention so that she would be on notice at that point that that statement, it's either should not have been made. But then in this case, nothing was done. And I will submit that after the objection by Ms. Collier, it was in writing. Everybody was there. She believed in good faith. I will submit that what she said was accurate because nothing was.
Mr. Wanagay,
Yes.
That's point B in time, but the statement in question was made at point A in time. The statement in the small claims matter. And so I understand what you're saying and your argument about what should have happened at point B, but focusing on point A, when your client made the statement in the small claims matter that the disciplinary matter had been dismissed because it was unsubstantiated, what you're arguing really is irrelevant to her state of mind at the time that statement was made. And that's what we need to focus on here, her state of mind and whether or not when she made that statement, she knew that it was false. And Office of Disciplinary Counsel has said there is no way she couldn't have known and that there was no basis for her to say it was dismissed. Please address that argument again. What was the basis for her to think it was dismissed?
Okay.
And I will say, you know, she was a lawyer. If she was and dismiss, you know, that's not a magic term only in the disciplinary world. A matter is dismissed in all sorts of legal matters, and that connotes finality. So how could she have thought that it was dismissed?
Legally speaking, the word dismissal, I will submit, does not connote finality in every circumstance. And I give an example. When you file a case, and then the first dismissal, and you say, oh, I was unable to serve, the case is dismissed, the statute has not run, is without prejudice, so that you can refile. However, there's a dismissal that we all know is dismissal with prejudice, which we'll say is actually final. In other words, let's assume for 1 minute she says dismissed, unsubstantiated. That doesn't mean that it's dismissed with prejudice. If you look at it in a legal sense, dismissed with prejudice is what makes it final. The matter being dismissed, she may refile it at a later time, but right now, as far as I am concerned, based on the information that was available to me, in reading paragraph 5 of the complaint by Ms. Collier, and then the complaint by Ms. Lake, bar counsel chose not to proceed on those. All they did was, I admitted that I engaged in dishonesty and made false statements in my pro hac vice application. That's the admission. But then the complaint by Ms. Collier was that she was able to practice in Los Angeles. But then there's nothing in the record. And bar counsel obviously must not have been able to sustain it. That's why they did not produce or proceed with that charge. So on April 14th, when she filed the subsequent matter, using the A and B example in terms of point A in this sense for me will be there's a negotiated discipline. The negotiated discipline doesn't mention anything that Ms. Collier complained, all 8 bullets. What bar counsel, I admitted to bar counsel, is the false statement in my pro hac vice application. But then it's not about the ability to practice in California that Ms. Collier complained about. So when she files it on the 14th of April, the small claims matter, I will submit that she believed in good faith that the bar counsel is not proceeding with it. The documents and the responses that we gave them must be satisfactory that Ms. Collier's complaint is not going anywhere. And then Ms. Lake's complaint isn't going anywhere. I will submit that just because bar counsel starts an investigation of somebody who wrote a bad check or an attorney who writes a bad check, and then they stumble upon a misappropriation, does not mean that if I state, for example, that the complaint about writing the bad check, if it was uttered, but then the money had not cleared the account, or for some defenses that they don't proceed with it, what starts an investigation is one thing, but then what the investigation ultimately reveals is something entirely different. And that's the argument that Ms. Carter was making. And that's, I will submit, was her thinking when she used the word unsubstantiated and was dismissed. And then one board member was asking, what could have been said that would be satisfactory? Examples were posed, but then, disciplinary counsel, that's not even satisfactory. So I will submit that at the very least, poor choice of words. But then the question then becomes, what will be the sanction that is appropriate under these circumstances? And I do believe that she's already been punished. If the board is not going to dismiss this matter, I believe that the appropriate sanction will be essential. Whatever discipline and whatever training that we need her to get, she's already gotten it based on the matter that Ms. Collier filed that led to the investigation that produced what was ultimately charged, negotiated, and agreed to by the parties. So based on those reasons and any other reasons that may appear to the board, I ask that the board find, as we've requested on behalf of Ms. Jihan. Thank you.
Thank you, Mr. Wanigay and Mr. Metzler.